G- Good afternoon. I'm Walt Bauer, and I'd like to welcome you to the Human Development Institute's first fall seminar. We welcome the participants who are joining us online through Zoom, as well as the participants who are here with us at the live presentation at the University of Kentucky. Our presenter will provide an opportunity for questions this afternoon. We welcome questions from all of our participants. If you're online, please type your questions in the chat box, or you can use your microphone and ask a question live. Should you have any questions about CEU credits, you can contact me. Please take a moment at the conclusion of the seminar to complete our brief evaluation. The evaluation will be sent to your email address immediately after the seminar. It's really helpful as we plan for upcoming seminars. Now, to introduce today's speaker, Dr. Peter Blank is University Professor at Syracuse University, which is the highest faculty rank granted to 8 prior individuals in the history of the university. He is also chairman of the Burton Blatt Institute. The title of the seminar today is Disability Law and Policy, Emerging Trends and Future Practice. I'm now going to turn it over to our presenter.
Thank you, Walt. It's a great pleasure to be here. See some familiar faces and friends, and University of Kentucky reminds me very much of where we used to live at the University of Iowa. We were Hawkeyes, a very vibrant, intellectually interesting town located in a rural state with some great people I see in the room. So thank you, Walt, and it's a pleasure to be at such a fine institute such as the HDI, the great work that you guys do and our collaborations with you. Thank you. I'm a little bit of an odd bird. I focus on law and policy in regard to disability, but primarily from an evidence-based approach. I was trained as an experimental social psychologist. I got my PhD first, as you heard, and then taught a little bit in that area, and then went on to law school and got very interested initially in patients' rights, got very interested in disability-related issues, particularly in the area of cognitive and mental health disabilities, and was very fortunate early in my career to go to Iowa to work in the state where the author of the Americans with Disabilities Act, Senator Tom Harkin, one of the major authors, was getting underway early in the 1990s to really try to understand this revolutionary, really at the time, piece of federal legislation, which was in many ways a model for the world to come. I also have the great privilege at Syracuse, to take off my coat, Walt, be a little less formal, if that's okay, to lead a think tank named the Burton Blatt Institute. Burton Blatt was a beloved dean of education at the Syracuse University. Syracuse has a long history of focus on disability issues. We have been fortunate to have the first disability studies program in the United States, the first disability cultural center, very active student groups, beyond compliance groups. It's called BCC. I forget what the other C stands for, but focuses on really pushing the envelope beyond minimal compliance to ensure the rights of persons with disabilities in society. In about the mid-1970s, and I know I've told some of you this story, Burton Blatt and his colleague Fred Kaplan, with a hidden camera on their belts, made their way into institutions, primarily at that time for persons with mental retardation. Today we say intellectual disability, and made a photographic expose of what was then really the horrific conditions facing people living in those institutions. The expose was called Christmas in Purgatory. It was done at Christmas time, and it was a hellish place to be in. And it really lit the fires of reform with regard to America's consciousness about the plight of so many people with disabilities at that time, particularly with intellectual disabilities, but other disabilities as well, who were out of sight and out of mind, living in conditions that we would want none of our loved ones or friends or anybody we knew to live in. So after I worked at Iowa for quite a bit, doing some early research on the ADA, workplace accommodations, on employer corporate culture, on public buildings and accommodations, Ended up at Syracuse, in part because of this rich history. Was fortunate to start. Burton Blatt had passed away. He had many friends and supporters. And the university endowed a fairly significant institute, BBI, Burton Blatt Institute, now with offices in Washington, D.C., Atlanta, head by our leadership team, Barry Whaley here, who will talk later. And we have tried to become a real strong player at the interface of law, policy, and evidence-based systems change. We really have tried to focus on cross-disability issues, and myself and many others, either at the BBI, have close family members with disabilities or are people with disabilities themselves, visible or non-visible. And it's really driven by grassroots understanding, which I'll talk about in a little bit, from an interdisciplinary perspective, to try to create rigor in a field where often there's not empirical research to support many of the premises that have been underway. Although there is a lot of good research in the area, we try to support and develop evidence-based approaches to new policies, programs, and practices. Our main areas of focus, of course, are on community integration, employment, universally designed and accessible physical and virtual technologies, as well as a focus on the implementation of laws, policies, both at the federal and state levels. We're working with us, physicians, economists, sociologists, psychologists, social workers, a whole range of cross-disciplinary folks as well, which we value terrifically, to focus on disability from this interdisciplinary perspective. And as we were talking about yesterday, at this time, there's going to be some need for a harmonization in the disability community, which maybe hasn't existed enough with regard to cross-disability issues, because as we were saying the other day, no one group now really in this environment is capable of strong policy change at the state or national level without a unified, strong cohort behind it. Now, as I say, I'm kind of an odd bird. So I'm a law professor. I'm a social science researcher. So I teach and I do research, but I also act in cases, typically pro bono, what are called impact cases, hopefully cases that not only make an important point in the particular case, as the P&A does and others in this state, but have implications for broader practice. And the disability area, of course, builds on, as you know, prior civil rights models, particularly the race and gender models, and the great strides that have been made in that area. But it's similar to, but different than in many ways, those civil rights models. It's similar to, because of its anti-discrimination principles. People should not be discriminated against on the basis of their skin color or their gender or the fact that they have a disability. But it's dissimilar, and that's where the rub often comes in terms of criticism, that there are affirmative obligations required to level the playing field, as you know. And I don't mean in terms of affirmative action, although not that that's a good or bad thing, but the disability community in the legal sense is constantly being pulled over into kind of that mindset. I mean affirmative in the sense that there should be an equal opportunity for people to participate if they're otherwise qualified, which many people I deal with are, in employment, governmental activities, or any activities you think of. And this is seen, in, of course, in United States Supreme Court cases. Your neighboring state, Tennessee, in Tennessee versus Lane, had one of the most important Supreme Court cases under the Americans with Disabilities Act. I'm sure many of you are familiar with it. A gentleman who was called to court for some reason. The judge decided to hold court on the second floor. The gentleman used a wheelchair, and he had to crawl up the steps in America to get into the courthouse. The United States Supreme Court said that was intolerable, and it violated the Americans with Disabilities Act. And there was no reason that that person shouldn't otherwise have an accessible opportunity as a citizen to participate in his court defense just as any other citizen would. Now, This tension that I talk about in terms of similar and difference is in many ways, we could spend a whole day on this, kind of at the core of the tension in the disability model today, as you know. So the model today, many people refer to as a social ecological model, which considers both the person in the context of the environment. And many people will say, many of my colleagues and others, for example, in people who use a wheelchair, the world many times is built around an able-bodied model. By the way, that could be physical or cognitive. It could be many different dimensions. And many people are just as qualified to participate with disabilities with accommodation. And it doesn't necessarily, this is the rub often from the critique, give people with disabilities so-called an unfair advantage for participation just because they may be getting extra time on an examination. They may have access to facilities that maybe it costs a little more to get a ramp in, and other sorts of basic accommodations. Now, the United States Supreme Court, interestingly, in a case about golf, which you probably heard about, grappled with this point, and the implications really transcended golf, but it happened to be around a sport which the justices were particularly interested in. In Casey Martin versus PGA, or PGA versus Casey Martin, the facts really are prototypical of the types of cases that I see. But this is kind of a fun example, made it all the way up to the United States Supreme Court. Casey Martin, fibromyalgia, had terrible leg problems. He was an otherwise stellar golfer, good enough to play on the PGA Tour. It got to the point where he was playing on the PGA Tour where he requested as an accommodation a golf cart. His argument being that the sport of golf is getting up to the tee, hitting the ball, and then going to the next spot and hitting the ball into the cup in the least number of strokes. The PGA denied his request to use a golf cart because they thought it would be unfair, because they thought it would change the nature of golf itself. The typical, prototypical accommodation dispute, whether you're an employer or a professor who's objecting to a student having time and a half because they have ADHD, it's somehow going to impugn the integrity of the examination, and so forth. There's no research that supports that, by the way. So this golf dispute went to the United States Supreme Court eventually with golf professionals on both sides, Lee Trevino, Tiger Woods, whoever. It was before Tiger Woods. Some saying, yeah, you know, if he rides a golf cart, he's going to have less exertion, he's going to be more relaxed, and it's an advantage for him. Same topic, other golf leaders said, you know, he's at a disadvantage if he drives a golf cart. He doesn't have a feel for the course, he doesn't get into a rhythm, he can't talk with his caddy, and so there was a factual question as to whether or not this request for accommodation substantially changed the nature of the endeavor. This is the prototypical situation in any accommodation issue. This is just a nice illustration. The Supreme Court, in a long decision with dissents, eventually found that there was nothing inherent in the riding of a cart that changed the nature of the golf competition, so that it was a reasonable accommodation for Casey Martin to drive in a golf cart. They did an analysis. They looked at all the... Now, the interesting thing also I always write about is Justice, may he rest in peace, Justice Scalia's dissent. Justice Scalia basically took the position that he would write, Justice Scalia would write things like, oh, our poor golfers, you know, now they have to put up with golf carts when they don't want to. And Justice Scalia wrote an example of what he thought to be related to the unfairness of this decision. And no surprise, because this is what we deal with all the time, mental stigma, mental health stigma. His example was, what about a child with a cognitive disability who needed a fourth strike instead of just 3 strikes and able to play baseball fairly. Now, of course, it's an absurd, that maybe arguably would change the nature of the game. But you could see this natural reaction in many people, this rub that ironically, not unlike affirmative action, I guess in some ways, that somehow these individuals who are otherwise denied access are getting some sort of special advantage by participation or in winning the competition. And I can't tell you how often, I'd be interested in your reaction, that theme of life is so interesting and something we have studied, we've tried to study through attitudinal surveys, through our studies on corporate culture and organizational culture, that somehow either people with disabilities don't fit in or they're getting a special advantage. Either way, it's a loss for the people with disabilities. Now, to me, interestingly also, not only are these attitudes here today, but in another part of my life, I've been very fortunate to work on a very large grant with a Nobel laureate who has passed away, Robert Fogel, who wrote a book called Time on the Cross, but he won the Nobel Prize for his work on the emergence of railroads in the United States in the late 1800s. Robert Fogel built a team around him to study this cohort of individuals who basically participated in the United States Civil War. Sometimes in the South they say the War of Aggression, Northern Aggression, or the war between the states, but we'll call it the Civil War, and follow them basically from cradle to death. Thousands of soldiers and also thousands of U.S. colored troops, which at the time were the African American troops, freed slaves, and northern freedmen. And the beauty of this grant, it had never been done before. It was sponsored by the National Institute on Aging. And of course, Fogel was interested and brilliant about, he was focused on issues of mortality and aging and retirement, kind of economic issues. I was very fortunate to have access to that team, be a part of studies on that team. And I was interested in the evolution of attitudes and thinking about disability policy in the United States, in part because this was the first and largest cohort the United States had seen of individuals with disabilities who were receiving governmental services. There was no Social Security at that time. There was no Rehab Act. There was nothing like it. There was the pension system. And the pension system for Civil War veterans was basically compensation or injury, similar to a workman's compensation payment, that you were paid for how much you were substantially limited in working. So we have studied the medical records of these individuals for years, detailed medical records. This was not limited science. They didn't have the tools that we had, but to get a pension, you had to have the detailed medical examination every year, and they were fairly sophisticated, and surgeons' records, and census records, and war records. And the upshot was, in a different book we wrote about race, ethnicity, and disability, and the evolution of thinking about disability in the United States, there was terrific discrimination, holding constant severity of disability. In other words, same people presenting based on race, based on ethnicity. The Irish were particularly discriminated against. The Slavic nations, people were particularly discriminated against. The Anglo-Saxons were not. And as a function of disability, with mental illness, what's so-called PTSD, they called it nervous disorder, anything that was not visible, although had terrific symptoms, just as my other physical disabilities have, they wanted nothing to do with it. And this line of research, in part, was meant to validate contemporary ideas about worthiness of disability. There's a hierarchy of disabilities. Often mental disabilities are perceived as less worthy, less viable, more prone to faking, and how this system kind of developed with this. Interestingly, the pension system kind of died out in 1910, although there were some widows and survivors. And then we got into World War I, where the focus differently was, rather than just on compensation, was on the beginnings of voc rehab, the rehabilitation community. World War II, we get to GI Bill, kind of education, reintegration into work. Vietnam, of course, we get really hard knowledge about PTSD and mental illness. I tell you this because I don't want to deviate too far, but because from an interdisciplinary perspective, we're very interested in understanding these hierarchies of disability and the reaction to different types of disabilities. So the next book in our series, which is coming out in 2018, I write with a really fine historian from Jackson, Mississippi, at Mississippi State, who balanced the northern and southern perspective. The next book, which is coming out, is called Heavy Laden, which is a term from Handel's Messiah, which is drawn from Matthew, I think, in the Gospel. Mental illness, PTSD, and suicide among Civil War veterans, and implications for the contemporary suicide epidemic today, involving many veterans with disabilities. Again, trying to understand the relationship between disability, policy, society, and law. Now, at the Burton Blatt Institute, the research agendas often are very much driven by also the cases that I get involved with and the kind of work we do in the applied setting. I'll never forget talking about stigma, which started us focusing on stigma heavily just because my team's experience, our team's experience. One of the first cases I was ever involved with was in Madison, Wisconsin. And that's a nice college town. The Badgers are there, UW, and they had a Chuck E. Cheese pizza parlor. Chuck E. Cheese, stay away from if you don't have little children. Chucky the Mouse, tickets for prizes, pizza, and otherwise chaos in the ball cage and other sorts of things. They had hired a man named Don Perkel, who was called mental retardation at the time. Today we would say intellectual disability. He was nonverbal. He communicated via sign board. And he had been terminated by the Chuck E. Cheese I'm going to tell you about. But I had been very fortunate at the time to be working with the Clinton administration on the President's Committee on the Employment of People with Disabilities. And this case came to me through a really distinguished disability leader at the time named Paul Miller, who was working in the White House and then eventually became a commissioner of the Equal Employment Opportunity Commission. And so what happened with Don was he was working in this Chuck E. Cheese doing a great job. And I believe it was his first job out of a segregated sheltered workshop. So he had a history of non-inclusion in daily life. And he was doing janitorial and pizza making. And one day, a regional manager comes up from Texas and sees Don and literally almost says to the manager on site, "Fire that guy, I don't like the way he looks." I don't like the way he looks is discrimination on the basis of disability. I mean, you can't get a better statement than that. The staff people on site would not fire Don, to their credit. As a matter of fact, they emailed the head office saying, well, what kind of equal opportunity employer are we? So this guy goes away. He comes back a month or two later, and he says, I told you to fire that guy. And if you don't fire him, I'm going to fire him myself. Not the smartest organizational move you can imagine, soon after the Americans with Disabilities Act is passed. So he fires Don, and God bless them, the whole staff quit in protest, become government witnesses. And the local protection and advocacy, the local EEOC organization took up this case, and it was terrific leadership by the local advocacy organizations and the EEOC and the government. I was very fortunate to advise the government as an expert on inclusion in society, inclusive work, at that time, kind of the segregation in sheltered workshops, self-determination, and so forth. And I had a great opportunity to testify before the judge about the research that I was just talking about and we were interested in. So there's a 5-day trial or so, and Don wins $80,000 in lost wages. And amazingly, though, the jury after that decides to ask the judge, I believe, a question. They submitted a question to the judge. The question was essentially, can we also award Don Perkel $13 million in punitive damages so this never happens again in our community? And the judge allowed it. Now, of course, lawyers being lawyers, we have good lawyers here. They appealed that, and you can often hire psychiatrists or other professionals for a certain amount of money. They got a psychiatrist in their motion to say that because of Don Perkel's intellectual disability, there's no way he would enjoy the fruits of $13 million. With a straight face, that was said. And they paid everybody a lot of money to say that. And of course, essentially, the great counsel that we had said, he'll enjoy every penny of that $13 million. Don't you worry about that. And the judgment was upheld. Now, there are caps under the Americans with Disabilities Act for certain levels of compensation you can get. But it was, to my understanding, it was the largest jury award of its kind, and maybe still today, for discrimination that occurred in the employment context. And I tell you that story because these types of stories, for me at least, so ground me in how I want to approach, in a rigorous scientific way. This is not to just whitewash. If we get a bad or contra result, then we'll say it. But it was so apparent that the organizational culture did not get disability. It was so apparent, in my opinion, that the CEO dug his heels in, it was a man at the time, to support his regional manager, and then began spending literally millions of dollars in legal fees to manage this case, all for something that could have been settled for nothing. So as a result of that, me and many others on our team, we got very interested in organizational culture. What drives thinking like this about disability? What did we really mean by diversity and inclusion in organizations from a disability perspective? Can disability be properly seen as an element of diversity? Some of which we take for granted today, but this was in the 1990s, soon after the ADA was passed, which led us to be funded by the U.S. Department of Labor, which was a lot of fun, to actually do case studies and large-scale surveys of large and small organizations to try to understand what drove these organizations. With some great economists, for example, Doug Cruz, Lisa Scher, and others, we did a book on this subsequent. We unpacked and understood that, in fact, there are more fair and more open organizations. No surprise. My mother would have said, you had to tell me that in 100 pages. I could have told you that in 2 sentences. But, you know, social scientists have to live, and so we did our thing. And that, in fact, those organizations that are more open and interested in diversity tend to accommodate their individuals more. Surprise, surprise. These accommodations net benefit, we've studied this, to the dollar, don't cost more money. They actually make money if you look at it in terms of how they benefit everybody, how it enables productive employees to stay on the job, and how it advances a community in terms of thinking about disability. And as I say, I can't tell you how many cases I've had, and maybe you guys have similar experiences, in which I have to continue to make this argument that somehow you're not losing money, you're spending money to make money. That this, when done well, can create value to the organization. Now, at the Burton Blatt Institute, as I said, we study a lot about the Americans with Disabilities Act.